Hello, this is a presentation of Family First Legal, Mediation and Collaborative Law Firms. This presentation will be on modifying custody in Maryland. This presentation is for educational purposes only and not for the purpose of providing legal advice. Please consult an attorney if you need legal advice. Here's an overview of what we will cover here today. We will be looking at the what, the who, the why of custody modification. We'll be looking at the legal requirements for child custody modification. Next, we will look at what is good evidence in a custody modification case. And finally, we will look at the modification by agreement. So first, what, who, and why of custody modification? What is custody modification? Custody modification is the process of modifying a prior order, whether it was your initial order or a previously modified order regarding custody. Who can modify custody? That's going to be generally the parties who were involved with the prior custody order. So that might be the parents, the mom and the dad. If you qualify in one of those roles and you were involved in the prior order, then you can file for modification. In some circumstances, the child can file for modification. If the child is over the age of 16 and they feel the order no longer addresses their needs, they can file for modification as well. This does not mean it will be granted, but the child does have the opportunity to be heard by the court. Others who may file for a modification in a custody case are third-party interveners who have provided care for the child and who now have an interest in the case. They can file in as an intervener in the case. Why would they file a modification, or why would you file a modification? You file a modification to modify or change a prior order of the court. And you usually file that because you're trying to get the court to change something that's harmful to your child or that has now affects your child in a way that it didn't affect them previously when the order was done. So we'll get a little more in detail about all of that. So, looking at the legal requirements that the court has for a custody modification, there is usually a two-pronged analysis that the court does to determine if you have a right to a custody modification. If you don't meet the first prong, then you will not get to the second prong. The first prong requires that there has been a material change in circumstance. And to go a step further, the material change in circumstance has to detrimentally or harmfully affect the child or children in question. Once you prove to the court that there has been a material change that detrimentally affects the child or children, then the court wants to look at whether what the change you're requesting in the custody order is in the best interest of the child or not. So when you're thinking about a modification, you not only have to prove that there has been a material change in circumstance that detrimentally affects the child, you also have to prove to the court that the thing you're asking them to change in the order or how you're asking them to change the order is in the best interest of the minor child or children in that case. So material changes could be anything from the child's mental health having changed to the child having some behavioral issues in school. It could also be a change in the parent's circumstances which detrimentally affect the child. If a parent becomes homeless and that parent is the primary custodian, that would be a huge problem if the child is now homeless also because the parent is homeless. So that would be a material change in circumstance. It also might be a reason for emergency custody change. But that's not something we're going to address here. But just keep that in mind. So first you will need to prove that there's a material change in circumstance, and then you will need to prove that the thing in the order that you're seeking to change is in the best interest of the child to change. If you're able to do that, then you will be able to prove to the court that you have an actual legitimate reason for a custody modification. Now, in order to get that custody modification and to prove those two prongs, you must show the court evidence supporting any claim that you make regarding the change in circumstance or the best interest of the child. That evidence, you'll want to list that out and know that evidence in advance. You'll want to know what documentary evidence do I have? Do I have text messages, social media posts? Do I have documents from a professional like a doctor or a therapist or even the school? Do I have voice recordings of the child or voice recordings of conversations? Do I have video of an incident? Do I have police reports? You'll want to have all that type of evidence in order to show the court that what you're saying is a material change is actually exists, and to corroborate your story. In addition, you might want to have testamentary evidence. That means having witnesses to testify and corroborate the evidence that you presented. So if you're saying something, it's one thing, but if multiple people are saying the exact same thing, it makes the court believe that this may have really happened as you stated it has happened. Corroborating evidence is very important to your case. I do highly recommend that before filing a custody modification that you consult with an attorney and that you have all of the evidence that you think you're going to be able to use to support your case with you when you consult with the attorney, so the attorney can help you identify what's good evidence and what's not good evidence. And also you'll want an attorney to assist you in understanding whether you have a material change in circumstances that the court would even consider. These are all valid things for you to consider as you're deciding whether you're going to file for a custody modification or not. So after you have good evidence, then you would move forward with a litigation. But in lieu of litigation, or before you get into litigation, you may want to consider doing a modification by agreement. It may still require you to gather evidence as we discussed before, but really this is more about negotiating or mediating. Negotiation basically means you are going to work with the other party to try to come to an agreement about what things need to change from the prior order in order to address a new issue. You can do that negotiation one-to-one with the other party, or you can have a third party involved, or sometimes even a fourth party where you might be represented by an attorney and the other party might be represented by an attorney, and the attorneys negotiate the agreement between the two of you all. That's a negotiation. Negotiation does not require a third party, but may involve a third or even a fourth party. Mediation, on the other hand, does involve a third party, and the third party is a neutral person. It doesn't represent you, doesn't represent the other party. Instead, this person hears the major issues in the case and tries to help you and the other party find common ground in order to come to an agreement on the issues that you cannot agree on. The mediator or the negotiator might assist you in writing up a new plan, a new parenting plan for how you all will interact around legal custody and around physical custody. That plan, if you're able to negotiate or get a plan through mediation, that plan can be filed with the court and prevent you from having to go through a long drawn out litigation. As a matter of fact, you may not have to go to any hearings if you're able to get this agreement done earlier on after filing or prior to filing your case again in court for a modification. So this is a good option, and I highly recommend this option. Again, this is also something you may want to talk with an attorney about before you enter into mediation or even negotiation. And if you are using an attorney or a mediator, I do recommend interviewing them and making sure they understand your family dynamics and that they are willing to work in a direction that you are looking for before hiring them. Thank you for your attention and your time. This has been a presentation by Family First Legal Mediation and Collaborative Law Firm on modifying custody in Maryland. Again, this has been for educational purposes. If you need more information or you would like a legal consultation, please do not hesitate to reach out to us or an attorney in your local area. For more information about our firm or to get a legal consultation with us, please reach out to us on the web at www.fflmd.com or on social media at Family First Legal. Thank you.